My name's Chris, and I'm going to talk about racial profiling today. So a central question for me in my law practice is why, if the law is clear that racial profiling is illegal, which it is, and if we know that it happens all the time, which it does, why are there so few positive findings of racial profiling in the case law? Today, I don't really have a whole lot of time to go into the why because it's a very fraught question, but I do hope to talk a little bit about the how we as practitioners can increase the number of positive findings of racial profiling, how we can bring justice for our clients when this happens to them, and what are some of the tools that we can use around that. I mean, just briefly speaking, I think the reason why is because it's very difficult for judges to find that police are liars in the first place, for all kinds of reasons, and to suggest further that the police are racist liars is a pretty tough proposition for a lot of judges to accept, but that's what we have to do. So first I'm going to talk about how we can frame the law in a way that's helpful to us. Second, I'm going to talk about what indicators we can point to that the social science research recognizes as indicative of racial profiling and how we can make that argument. And third, I'm going to talk about what tools in cross-examination of police officers we can use. As many of you I'm sure know, these are very tough applications to bring. They force us to marshal all of the skills that we learn as defense lawyers and execute them perfectly. You have to be fantastic at submissions. You have to be fantastic at cross-examination of the toughest witnesses there are to cross-examine, police officers, professional witnesses who are quite good at this thing. And you have to know the law like the back of your hand. So these are tough applications, but hopefully I can help you make them. And the jumping off point I'm using for this talk is Professor Tanovich's paper called Applying the Racial Profiling Correspondence Test, which he wrote for this year's 6-minute criminal lawyer. I think it's probably available online, but it's essential reading if you're going to bring this kind of application, or if you're going to adjudicate this kind of application, for someone else in the audience. So turning first to the law and how we can frame it. The law is very clear. Racial profiling is illegal. Section 9 of the Charter says that everyone has a right against arbitrary detention or imprisonment if the police officers investigate or detain or arrest somebody in whole or in part because of racial stereotypes. That is an arbitrary detention. It's a violation of Section 9 of the Charter. Just to read you the definition from the leading case on the issue of racial profiling called Perth and Peel Regional Police, the paragraph 89 and 90 from Ontario Court of Appeal. Racial profiling occurs when race or racialized stereotypes about offending or dangerousness are used, consciously or unconsciously, to any degree in suspect selection or suspect treatment. The one exception is where race is used as part of a known suspect's physical description. The description is detailed, and an individual is investigated because he or she reasonably matches that description. So that's the definition of racial profiling. You're never ever going to find a case where the police say, yeah, you know, the guy was black, and that's why I stopped him. Seems suspicious to me. So in the result, you have to rely on circumstantial evidence, the inferences that can be drawn from the circumstances of the case. And Professor Tanovich calls this the correspondence test. Do the facts as they occurred on the night in question, the day in question that your client was arrested, correspond to what we know about how racial profiling works? And he gets that from the leading criminal case on racial profiling called the Queen and Brown, which is from our Court of Appeal as well. It's a case, I think, of Justice John Morden. And the specific quote from that is at paragraph 44 and 46, where the evidence shows that the circumstances correspond to the phenomenon of racial profiling. The record is then capable of supporting the finding that the stop was based upon racial profiling. And the court goes on to talk about how the courts assisted, this is from Justice Jordan back in that Perk case I was talking about, paragraphs 95 and 96. The courts, assisted by various studies, academic writings, and expert evidence, have come to recognize a variety of factual indicators that can support the inference that police conduct was racially motivated, despite the existence of an apparent justification for that conduct. And the indicators of racial profiling recognized in the literature by experts and in the case law can assist a trier of fact in deciding what inferences should or should not be drawn and what testimony should or should not be accepted. So that means that, as Justice Rudnicki said, judges should take judicial notice. Systemic racism exists. It is real, it happens all the time. There's all kinds of literature that's cited in these cases that talks about how it plays out, and you can point to that and say, Your Honor, you have to take judicial notice of this, and that you have to use it in assisting you in assessing the credibility of these police officers. So yes, that's the law. The law seems to be quite helpful for the defense, right? You can look at circumstantial factors. You don't have to necessarily believe the police at face value. But Professor Tanovich in this paper actually looks for all of the positive findings of racial profiling in the post-charter era from 1982 to 2017, and he found 27 decisions, 27 in 35 years. So that's the problem we're confronting, despite the fact that apparently the law is pretty helpful for the defense on this issue. It just never gets found. I think there's a lot of reasons for that. I think that probably as defense lawyers we're not raising these issues enough. But I also think that judges simply aren't receptive to it for the reasons I've discussed earlier. So how do we make these arguments? What tactical decisions can we make in order to strengthen our applications here? First, we can point to these indicators that Professor Tanovich points to, and that in Perth and Peel Regional Police we say are something that the judges should consider. And I'm just going to review them briefly here. I'm sure a lot of you are familiar with these. There's lots of great literature you can read or you can file with the court in order to point to these indicators. Obviously, the explicit use of race, you don't see that often, but sometimes you'll see police officers saying things like, well, we know that these people are involved in grow operations, and that's why we investigated this person. It doesn't happen often, but when it does happen, obviously, that's an indicator of racial profiling. Another is the heightened use of general investigative powers in racialized neighborhoods. So, street checks and carding. If the police are just sort of driving around on patrol and stopping people, and the neighborhood is racialized, that's something you can point to as one indicator. Another is driving while black. So the quote-unquote driving while black. Highly discretionary and minor statutory powers used to justify criminal investigations. So jaywalking, or in the driving context, I wanted to check the plates, I wanted to check the license, I wanted to check the insurance, and there was no other reason. It just so happened the guy was on bail. These kinds of things are something you can point to as an indicator of racial profiling. Officers relying on their spidey sense, ambiguous behavior, nervousness, the guy was staring at me, and that's why I decided to detain him and have a conversation with him. That's an indicator of racial profiling, according to literature. Obviously, so the exception to racial profiling is where there's a specific description of a person that includes race, but if that's not a reasonable justification in the circumstances, that's an indicator of racial profiling. So, for example, where they're saying, well, yes, I stopped him because they had a suspect description come over the radio and it said a black person, and so I stopped the black person. You can point to the differences between the actual way the client appears and what came over the radio as indicative of that that's not an appropriate justification. And overreaction. And this is actually, I think, a really important thing. So when officers interact with racialized people, we know that they kind of tend to use every discretionary decision that they have in order to exert the maximum amount of state control over that person. So, for example, I see a guy, he's not wearing a seatbelt, I'm a police officer. I have an option to simply say, sir, you're not wearing your seatbelt, put it back on, have a nice day. I don't have to get out of my car, or I can do that at the stoplight. But instead, I decide to pull him over. I can go up to the person and I can say, sir, you've got your seatbelt on, can you please put it on? Maybe give him a ticket without running his plate, but I run his plate. I can give him that ticket without having to run the identification of every single passenger in that car, right? Because they're not obviously involved in any suspected highway traffic or other criminal activity. But instead, I decide, me and my partner, to run everyone's identification. I can decide to simply have this interaction with this person who I say wasn't wearing their seatbelt without calling for backup, but instead I call for another police cruiser. I can have this conversation with this person. So let's say the person who wasn't wearing the seatbelt, I run their ID turns out they're on probation or they're on a bail and they're breaching it. So I can release them from the scene on a promise to appear, a Form 10. Right then and there I can do that. Instead, I decide to bring them to the station. I can release them from the station on a Form 10 or a promise to appear. And instead I decide to detain them for bail. I can search that person and put them in cells without having to subject them to the degrading or humiliating experience of a strip search. Instead, I ask for and receive permission to conduct a strip search. So these are all different factors you can point to in your applications that say these officers are being racist. They are using race as a factor when they are making their discretionary decisions about how to deal with this person. And so that's, again, another indicator you can point to, one of the ones that Professor Tanovich talks about when he's talking about, and Justice Dory talks about when they're talking about how to prove racial profiling in a particular case. But I don't think, I mean, so if you have those two things, you have the laws on our side, I think, it's pretty good for us. There's lots of indicators you can point to in order to be able to say, just circumstantially, Your Honor, I think this is racial profiling. I don't think that's ever going to be enough in a particular case, even if your client gets up there and testifies about it. Because I think what you have to do is you have to show these police officers are lying, just tactically. You have to get up there and you have to prove, you have to point to some objective thing that tends to show that the officers are misleading the court if you're going to have any success here. And I'm going to now try and give you some tips for how to do that. And again, for a lot of you, this is old hat, so bear with me. The first and most obvious are police notes. Police officers write notes as parts of their investigations, and they write them in little memo books, and we get disclosed them, photocopies of those as part of our constitutional obligation to disclosure. You want to be looking for whether or not the notes match the synopsis, the typed report by the police officer. So if the police officer says, you know, I stopped the guy for a driving infraction and I ultimately discovered that he was on probation or he was on bail or he had drugs in the vehicle or whatever the case may be, then you want to look at the notes and say, does it say I stopped the guy for a driving infraction? A lot of it, surprisingly, what you'll often find first is, okay, here's the officer who's written the vehicle information number, they've written the personal information of the client as well as all of the passengers in their notes, and then only later do they come in and write down, oh, you know, and I stopped for, like late entry, stopped for, you know, seatbelt. So that's one thing you can look to. Also look to whether or not, if there's multiple officers investigating, whether or not these multiple officers have the same kind of framework in their notes. In the case I did, the sort of main arresting officer, his notes were lined up. You know, I saw the seatbelt, I told the partner to pull him over, and then I went up to him and I had a conversation with him, and I you know, got his identification, I ran his name, and he was on probation. Whereas the partner, it was written as a criminal investigation from the start. That's how his notes were written. So another thing you can look to there. Another tool you can use is surveillance. So every Toronto police cruiser is equipped with an in-car camera system. Those are required to disclose to defense if you ask for them. Or in a civil case, if you're a plaintiff, you presumably be entitled to that information as well. And it's going to capture everything, every interaction with the police officer from the 30 seconds before the police officer turned the cherries on to the lights on the police cruiser to the moment they drop the client off at the police station. And if your client tells you, listen, without a shadow of doubt, the first thing that they said to me was, you guys are driving a nice car, how can you afford this car? I can't even afford this car. Then you want to get that video, because it's also, the officers are mic'd, because that's what they can do to get that information as well. Be alert to the fact that these videos have retention periods. Now, they're supposed to be retained in criminal cases and HTA cases for anywhere between 6 to 10 years, but there's a flaw in the system, or a loophole in the system, where if the officer marks the video as, either marks it as unrelated or else, or other, I think is the official thing, or if the officer fails to categorize it, like turns off the system before they categorize it, it only gets retained for 1 year. And crowns and police officers don't disclose this normally as initial disclosure. You have to ask for it. So for whatever reason, you forget to ask for this for a full year, it's gone. And you're going to have to bring a lost evidence application. So make sure to be asking for that early. And finally, a final note about the in-car system. There's a very detailed policy about it. So if ever there's an officer interaction and they're in a marked cruiser and they don't turn on their in-car, you can totally destroy them across with the procedure manual, the policy manual in hand. Okay, the next thing is radio records. So officers are required, not required, they have radios on them and they have radios in their car and they communicate with each other over the radio. It's obviously captured in real time and it's all recorded and it's recorded for some time after the system. Okay, so I've gone on way too long. Just very briefly, the radio records, you want those. The mobile data terminal records, so officers have computers in each of their cruisers. They enter information into these cruisers. It's tracked when they enter the information and what information they see when they get the readbacks from the mobile data terminals. And you can get disclosed all that as part of disclosure. Again, you have to ask for it. And obviously that's very important information because if they say, I ran your client right away, he was my only interest, I wasn't interested in the passenger or the driver, the other passenger or the driver, and it turns out the mobile data terminal says they ran your client last, that's a critical part of impeachment. And then finally, I referenced this earlier, but police memoranda, you want to get the policy manuals because they're going to be a fantastic tool to use. They're always going to agree, yes, I know the policy manual exists, yes, it's something I've read, and yes, it's something I'm familiar with. I would never be a police officer who doesn't read the policy manual, and then you can point to the specific issues of non-compliance and then illustrate them across. So those are the tips for being able to increase the credibility of police officers. Again, always a very difficult task. But finally, and I think this probably goes without saying, but you have to call your client on these applications. If you don't call your client, it's our onus. We have to prove this on the balance of probabilities. You need to call your client to get up there and tell his or her story about what happened. And so finally, just to wrap up, as a call to arms, and this is something that Professor Tanovich also canvasses in his paper, I think that defense lawyers are often reluctant to bring these applications. I think first we have a problem of cultural competence. A lot of white folks like me just didn't do the work, didn't do the research, didn't talk to people, don't know or understand what these issues are, and we have an obligation to do that, at the very least for our clients, if not a broader social obligation. And I think the second issue is tactical. I think we worry that if we raise these issues, that the trial judge is going to be hostile towards us. And if we can get into it another way, with just like, well, the officers didn't have grounds, then we don't have to worry about litigating this racial profiling question. I think that, and that's a decision I've actually made in the past, so it's hard to be critical of that decision. But I think that we need to be raising these issues. We need to be saying, Your Honor, I want you to decide this on the racial profiling question. We need to be, that's the only way we're going to increase the number of cases with positive findings is by raising it, litigating it, and getting the trial judges educated about these issues and broadening their scope. So those are my comments. Thank you very much.